Welcome back to Arrest Chronicles. Tonight, we're diving into an intense incident involving a suspected drunk driver. We'll break down every legal aspect, critique law enforcement's handling, and end with detailed ratings for everyone involved. Stay tuned till the end to see the scores.
Go stand in front of my Tahoe.
Yes, I have beat.
Okay.
I have beat DUI 3 times.
Okay, so, here's what we're doing. We are doing a DUI investigation now.
Here we see officers responding to a report of reckless driving and a near collision. Legally, this is a classic DUI investigation under probable cause. Probable cause is a cornerstone of the Fourth Amendment, allowing officers to investigate when they observe potential criminal activity like reckless driving. In Florida, operating a vehicle while impaired is governed by Florida Statutes Section 316.193, which defines DUI as driving with a BAC of 0.08% or higher or being impaired by drugs or alcohol. The driver's refusal to comply with basic instructions raises immediate red flags and could compound charges, such as resisting without violence, a second-degree misdemeanor under Florida law.
Go stand in front of my truck like I gave you a lawful order. I'm fixing to take you to jail for resisting. Turn around, put your hands behind your back.
No, sir. No.
Turn around and put your hands behind your back.
You are being aggressive.
Turn around and put your hands behind your back. I will not tell you again. Turn around and put your hands behind your back.
Brother, you got me.
Non-compliance begins to escalate here. The officer repeats lawful commands multiple times. Refusing lawful orders during a DUI investigation constitutes resisting without violence. Remember, resisting without violence is distinct from resisting with violence, a key legal differentiation. The officer's repeated orders also comply with de-escalation protocols outlined in many police departments' standard operating procedures, SOPs, showing an effort to avoid using force prematurely.
I got called out here. Apparently, he almost hit somebody walking down the sidewalk.
Okay.
He is extremely intoxicated. He was laying on the ground as I pulled up and tried to jump into his truck.
Okay.
So he is now going to jail for DUI and resisting.
This scene introduces a significant aspect of law enforcement, balancing enforcement with community care. Officers here ensure that minors in the household are safe while handling the suspect. Child welfare laws like Florida Statutes Section 827.03 protect children from potential neglect or harm in such cases. By addressing the family, officers fulfill their duty to prioritize safety beyond just the suspect's behavior.
All right. Do you have any kind of medical conditions at all?
Yes.
What kind of medical conditions do you have? You take any medication every day?
I have it in my bag.
Okay.
Right here. Okay. And all y'all got called.
Under Florida law, actual physical control of a vehicle while intoxicated is sufficient for a DUI charge. This means you don't have to be actively driving, the mere ability to operate the vehicle qualifies. The officer observed clear signs of impairment, such as slurred speech and vomit in the vehicle, further solidifying the case for probable cause. Legal precedent like State v. Gilliam, 582 so. 2D 610, Flaw 2D DC 1991, has upheld DUI charges based solely on such evidence.
May I ask a question?
What's your question?
If I roll through this, do you take me home?
No, sir. You're still going to jail.
And what the fuck's the matter?
Okay, so you're refusing to do field sobriety exercises? So are you telling me you're refusing?
Let's roll.
Back up. Do not walk up to me. A DUI investigation.
DUI? I wasn't in the vehicle when you found me.
So put your left foot on the line, right foot.
Was I in the vehicle?
Sir, are you going to follow my directions? Okay, turn around. Turn around and turn around and put your hands behind your back. I'm now going to count this as a refusal.
No, sir.
And it will be used against you in a court at a later date. Turn around and put your hands behind your back.
Not a later date.
Sir, turn around and put your hands behind your back.
Refusing field sobriety tests can have serious consequences. In Florida, implied consent laws, Florida Statutes Section 316.1932, state that by driving, you agree to submit to such tests. Refusal leads to automatic license suspension for up to 18 months. Here, the officer remains composed, but the suspect's repeated refusal demonstrates a misunderstanding of his legal rights, further escalating the situation. The officers ultimately arrest the suspect for DUI, resisting an officer without violence, and disorderly intoxication, per Florida Statute Section 856.011. This statute addresses public intoxication that endangers others. The officer's adherence to due process and refusal to escalate the encounter further showcases proper law enforcement procedure. Officer ratings. Officer conduct 9 out of 10. Score breakdown. Professionalism 3 of 3. De-escalation attempts 3 of 3. Adherence to legal standards 3/4, could have provided a clearer explanation of implied consent laws. Community care 8 out of 10. Ensuring the safety of the suspect's children was commendable, but some minor communication gaps were noted. This case highlights critical aspects of DUI laws and law enforcement procedures. It's a reminder of the dangers of driving under the influence and the importance of cooperation during police encounters. The officers demonstrated restraint and professionalism, while the suspect's actions compounded legal troubles. What are your thoughts on the ratings? Drop a comment below.